Welcome everyone, and thank you for joining us tonight for our third and final Australian Digital Alliance Forum 2023 satellite event with Professor Emily Hudson, who is joining us on her Monday morning from the UK. I'm Sarah Powell, the Executive Officer of the Australian Digital Alliance, and also joining us tonight is Elliot Bledsoe, our Copyright Officer. Before we start, I'd like to acknowledge the Ngunnawal and the Ngambri people as the first people and traditional owners of this land that I'm joining from in Canberra. I pay respects to their elders, past, present and emerging, and extend that respect to Aboriginal and Torres Strait Islander people, their communities and their cultures throughout Australia. And I invite those of you attending today's session to acknowledge in the chat the custodians and the lands from where you might be joining us from if you'd like to do so. And for those that may not be familiar with our organisation, the Australian Digital Alliance is a peak body in Australia promoting copyright law in the public interest. We are holding our annual ADA Copyright Forum, A Fair Future for Copyright, next week, or this week, on Friday, 17th of February. So check out our program online for more information and to buy a ticket. Tonight's session will explore the potential breadth and flexibilities of the fair dealing exception for Australia's copyright system. And joining us is Professor Emily Hudson, who is Professor of Law at the Dickson Poon School of Law in King's College, London. Emily joined King's in January 2015, having previously held academic posts at the University of Melbourne, University of Queensland and University of Oxford. Emily has a particular research interest in copyright law and for many years has undertaken work on copyright exceptions of cultural and educational institutions, which is showcased in her book, Drafting Copyright Exceptions from the Law in Books to the Law in Action. Some of Emily's recent research projects have related to fair dealing and online teaching, quotation norms in the publishing industry, copyright and open access, and controlled digital lending. Emily is also a director on the board of the ADA. So welcome, Emily. Thank you so much for being here, and I will hand it off to you.
Thank you very much. I assume you can hear me, Sarah. And what yes, I might just do is get the screen share set up. So with any luck, you can now also see those slides. Thank you so much, Sarah and Elliot and the ADA for inviting me to speak today. I gave my future self the gift of an early start. And I think it's one of those instances which just demonstrates how irrational we are, that thinking that our future selves would be unlike our present selves and that future me would be getting up early and having a yoga session and a jog around the block before coming in bright-eyed and bushy-tailed to give my presentation. It is quite early here, just after 7 a.m. local time. And hopefully I won't have too many cobwebs from having only just woken up relatively recently. But I'm very excited to be talking about this topic, making the most of fair dealing. And I was looking back at my digital files, at my records, and 2 years ago, I gave a presentation to the ADA called Getting Exceptions Right, a View from the UK. And at that time, the then Australian government had released information about a suite of proposed reforms to the Australian Copyright Act. And those reforms included things like a limited liability scheme for orphaned works, a new exception for quotation, expansion of Section 28 in relation to performances in classroom teaching to confirm that it applies to digital and online performances, a new exception for educational and other use of freely available materials, and so on and so forth. I understand that this package is sort of still sitting around hasn't actually been enacted, and that the sort of the current government is talking about further consultation. So we have this sort of ongoing interest in Australia in relation to copyright reform. Now, in my presentation in 2021, I spoke about UK experiences following the expansion of exceptions in 2014. And that expansion included the introduction of new fair dealing exceptions for quotation, for caricature, parody and pastiche, and for illustration for instruction. And I said that whilst much attention had been given in Australia to introducing fair use, so there'd been, through the ALRC and the Productivity Commission, calls for Australia to move to a fair use approach. But whilst there'd been this focus on fair use, the UK experience has suggested that expanded fair dealing is an approach worthy of proper consideration and is not merely an undesirable second best option. I then turned to the proposed Australian reforms, and my view was that although there were a lot of good elements in the proposals, the overall package risked being a third best option. And there were a number of reasons for this, including that the overall package seemed to increase statutory complexity with a series of detailed homegrown provisions that were limited to particular purposes and particular constituencies. And my sense was that many of these provisions seemed to be the product of compromise and risked going down the same path as that other great Australian innovation, Section 200 AB. And I suggested that rather than tinker here and there with Section 28 and an educational copying exception for freely available materials and so on and so forth, Australia should bite the bullet and introduce education as a fair dealing purpose, that to the extent quotation was on the table, that the proposed exception needed to be revised to bring it more closely into line with the text in the Berne Convention, in particular by removing the proposed limitation within the exception that it would only apply to particular purposes and to particular users. And that comment in relation to quotation highlighted not just a doctrinal analysis of quotation, but also reported experiences in the United Kingdom that the UK's quotation exception had been embraced quite readily by at least cultural institutions that I'd spoken with the study I was doing, that it really was doing some meaningful work in public-facing uses, so on-site and online uses. So that's what happened last time. And today, I want to discuss how to make the most of fair dealing. And I'm going to focus on illustration for instruction and quotation, and how the pandemic accelerated practices in relation to those exceptions in UK educational institutions and libraries. And there are two particular examples I'll focus on, being the use of films and other audiovisual works in online teaching, and then also controlled digital lending. And although I'm taking a UK focus, I'm hoping that you'll get a number of things out of the discussion. So some of these are just straight out legal arguments that you might be able to apply to the current Australian fair dealing exceptions. Need to bear in mind that there are differences in the legal framework in Australia, not just in relation to what the fair dealing exceptions say, but also the broader statutory environment. So for instance, to the extent we're talking about education, Australia has a statutory licensing scheme for education, whereas in the United Kingdom, the equivalent educational copying license, blanket license for higher educations is voluntary. So there are some differences, but there might be individual arguments or perspectives that you can take and apply in Australia. And also some ideas about what you might lobby for. Should you form the view that expanded fair dealing is a desirable option, what to lobby for, and also perhaps some of the things to avoid. So let's start then with talking about fair dealing in relation to online teaching. And I want to talk a little bit about the sort of background to a shift in the sector in which fair dealing was used and I think continues to be used to make content available to students, typically on the VLE, the virtual learning environment. In summer 2020, I was made aware of issues facing film studies departments around the UK. And in film studies, it's standard for students to attend screenings at which they watch the films that are the subject of the curriculum. And there were concerns that the pandemic would mean that these screenings could not be run in person, either because students were studying remotely, or because even if they could come to campus, there'll be various physical distancing requirements that meant people couldn't gather in groups to watch these films. And my answer in relation to what do we do was that there was a very strong case that online screenings of entire feature films to students could fall within the fair dealing exception for illustration for instruction. And I released guidance on SSRN in August 2020, which included detailed step-by-step analysis in relation to the legal arguments behind that position. This guidance was endorsed by the British Association of Film, Television and Screen Studies. Plus, I also spoke about the guidance in a number of webinars, including a number of closed sessions for university librarians. And as I hinted at earlier, my sense is that many universities adopted the position set out in the guidance. That is, that though they, where possible, had students watch films via authorized services such as Box of Broadcasts, that where there was a film that wasn't available on one of those platforms, they did use fair dealing to justify making a copy of that film available to students online on the VLE so that the students could then still watch the film. Why were they open to this approach? Well, I think one reason was that this was a mission critical activity and there were no other realistic options for universities. You couldn't have staff revise the syllabus across film studies modules so that they studied films that are available on the platforms to which universities have access. And there also seemed to be some acceptance that nor could you leave it to students to find the film themselves, for instance, by taking on Amazon Prime or Netflix subscriptions or what have you. Furthermore, this was an extension of existing interpretations of Section 32, the fair dealing exception, albeit that it was a bigger rather than an incremental step. So following the reforms of 2014 and prior to the pandemic, the sort of reported experiences in relation to illustration for instruction were that people were more confident that fair dealing applied for in-classroom uses, but there was still less confidence about whether those arguments translated to online teaching, putting content on the VLE and so forth. So there was already some momentum in this direction, and we get not so much as an incremental step, but a much bigger step building on that existing understanding of Section 32. And also, I think it's really important how much comfort universities were giving one another. And that's where things like the closed webinars were very important for institutions to talk with one another about what they were doing, bearing in mind that, for instance, my university, King's College London, never publicly released its policy. We did not release the official King's position. Instead, what we have is this guidance that I wrote, which is King's used to develop its approach, but is not the King's approach as such. Now what I'm wanting to do is to drill down into some of the details. And as I mentioned, to give you a sense of the sort of process that we took in understanding fair dealing, very much step by step. You've got a different statutory framework, different sets of exceptions, but as I mentioned, it may be that the process that we used and some of the individual arguments may be of interest both to people applying fair dealing in its current form, but also, as I said, to the extent you want to continue to lobby for expanded fair dealing in Australia. So I think one of the first things to note is always starting with the statute. And this is the exception that was introduced into the UK Copyright Statute in 2014. And I've added colour to words to try and sort of visually draw out the limbs of this provision. And because there's quite a lot of them, the way that I've now started to organize analysis of these sorts of provisions is to divide the analysis into the straightforward through to the more contentious, because I think with a provision like this, it looks like there's lots of limbs, but a number of them are very straightforward and are clearly met with the sorts of activities we'll be talking about today. So in asking whether or not putting a film on the VLE so students can access it is within fair dealing for the purposes of sole purpose of illustration for instruction, let's start with things which are clearly made out. Section 32 applies to all types of copyright subject matter. So it's clear it applies to dramatic works, to films. There's no limits in relation to publication status or the quantity copied. So the fact that one is copying entire feature films does not automatically bring it outside of the fair dealing provision. The fair dealing exception also applies to all rights of the copyright owner, which is significant because there could be a number of potential points at which teaching online with film could implicate copyright. So in particular, the reformatting or digitization to get the digital file and then that could be a reproduction, and then the actual act of making it available on the VLE could also raise issues of communication to the public. But all those steps will be caught potentially by fair dealing. It's also necessary that the work is accompanied by a sufficient acknowledgement, but this is relatively easy to satisfy. In the UK, the definition of a sufficient acknowledgement is an identification of the work and the author. So this is not an involved sort of academic citation. So it can be met quite straightforwardly. There might be that information in the film itself, on the VLE and so forth. And a final step or final element of Section 32, just to note, is that Section 32 is not limited to educational establishments. So all those bits are kind of the very straightforward bits. And I think too that the UK system, it also benefits from having fair dealing in single provisions rather than this sort of part 3, part 4 approach that still exists in Australia for many exceptions. So that's a very straightforward stuff. Then you have stuff that looks contentious but probably isn't. And one example of that is the requirement that the dealing is by a person giving or receiving instruction or preparing for same. And the reason why it looks contentious is that one literal reading is that Section 32 applies only to teachers and to students. So to the extent we're talking about, for instance, teaching with film, the finger that clicks the mouse to upload the film to the VLE needs to be attached to the body that's doing the actual teaching. And I think that this is wrong. First, it's problematic as a matter of a purposive construction. For fair dealing for education to work, it has to be at the institutional level. The institution provides the instruction through the activities of a broad range of people, not just the actual lecturer or academic or teacher in the room. And furthermore, any action for copyright infringement will typically be against the institution. It wouldn't make sense the teacher can shelter under fair dealing, but not the institution as well. So I think that the protection of Section 32, irrespective of whether it's the teacher or academic or librarian or a learning technologist who actually does the reformatting and digitization, uploading, I think that's implicit. And furthermore, even if we do take a literal interpretation, the ordinary meaning of person includes natural and corporate entities. So I think that limb is not something that institutions need or needed to worry about. There's also in the UK statute a qualification that the dealing must be for a non-commercial purpose. This has caused a lot of questions amongst UK librarians in relation to what does commercial mean. And in this context, the best answer is that you look to the act of the defendant and whether that act is directly or indirectly commercial. And when we think about using films in teaching, copies that are made in this context are not sold, they are not distributed for money, so they are not directly commercial. Could they be indirectly commercial on the basis that they're closely integrated with a commercial activity? In the Bentley textbook, the example is given of a pub playing films for free. that although such an act does not generate an income directly, it could be said to be indirectly commercial, as the pub also, if the pub, I should say, also sells patrons food and beverages for consumption while watching those films. So could you make a similar argument that the provision of excellent teaching resources, that the population of VLE with these resources is closely integrated with the business of education? And I think the difficulty here is if one took that approach, then almost everything that universities and schools do would be indirectly commercial, to the extent that those are fee-paying institutions, rendering Section 32 meaningless. So I think that the better argument is that we look to the Act. In this instance, it's neither directly nor indirectly commercial, and so that limb of Section 32 is also satisfied. Next thing that to discuss then is that the dealing needs to be for the sole purpose for illustration for instruction. And if I could give one recommendation, if you are pushing for fair dealing for the purpose of education, it would be to follow the Canadian approach and just write education. Do not write sole purpose of illustration for instruction. That language has really thrown people in relation to the scope of this exception. And indeed, that was partly caused by the Intellectual Property Office releasing guidance at the time in which the reforms came into effect, saying that Section 32 applies to uses solely to illustrate a point. And I'm not too sure whether that was correct at the time it was written, but later statements by the government suggest that Section 32 is not about illustrating points, it's about supporting and enriching and uses that complement teaching. As I said, I think it'd be far better just to use the language of education. And indeed, I think that approach where we give as much breadth as possible to the statutory purpose is the better one to take. I think that there is a lot to be said for the approach that is seen actually in the Canadian case law, in which the purposes are interpreted generously on the basis that the heavy lifting is done by fairness. So in thinking about whether or not online teaching with films is a fair dealing, we can say, look, it's clearly for educational purposes. Let's talk about the real issue. Is it fair? And I think that some of the case law and some of the Australian case law has really suffered from a quite excessive analysis of purpose rather than fairness. And I think even recently with the AGL and Greenpeace case, which related to Greenpeace's use of the AGL logo on various protest materials, that aspect of the case, considering criticism or review, seemed to spend a lot of time asking whether the use of a logo on protest materials was sufficiently critical, and saying that a number of them weren't. And I think that approach of really obsessively and closely scrutinizing the user's purpose, I think it would be better replaced by one in which you look much more at the fairness of their actions. So this brings us to fairness. Like most of the Australian fair dealing provisions, the UK statute does not define fairness, so we're looking to the case law. And the factors that have traditionally been relevant in the UK are also factors that get referred to in the Australian case law, this sort of idea that fairness is impressionistic. And the sort of factors that can be relevant include things like the amount taken, market effect, motivation of the defendant, and so forth. So you see these factors that tend to recur. And I think that in thinking about how fair dealing might apply to online teaching with film, one of the things that I included in the guidance was that universities should try to recreate as closely as possible the circumstances that exist for in-person screenings that are covered by Section 34. And this is another technique in terms of bolstering your fairness arguments, to ask, well, is there some other indication, including another statutory indication, that the government wanted to provide an accommodation for this type of dealing, this type of act? And in the UK statute, and there's a similar provision in the Australian Act, we have in Section 34 a provision which limits the meaning of public performance such that it does not extend to certain performances in educational establishments. And so if these acts aren't a public performance, they don't implicate copyright. You don't need to worry about infringement or getting permissions. And this reflects a policy consideration, a decision by government that these sorts of accommodations should be allowed. These sorts of acts should take place. However, in doctrinal terms, Section 34 only relates to in-person performances. And allowing a film to be accessed online on the VLE will implicate rights of reproduction and potentially communication to the public, as I mentioned earlier, and will be outside this section. But the existence of this section suggests that if the online performance is functionally equivalent to the in-person performance, the fair dealing analysis ought to result in that online act being within fair dealing. So you're using Section 34 to sort of help frame what is likely to make your use fair. And so in particular, you end up in thinking about fairness with all these strategies that institutions were using to bolster fairness, right? So which films can students watch? Well, the ones that are on the syllabus. You limit who can access the film and how, often by making films available for a more limited period of time. So basically the VLE does not look like the landing page of Netflix. You try to make sure that you're limiting the way in which students may use the films so that it's similar to those in-person screenings, right? Time limited availability of films on the syllabus to be watched by students in the module. There was a suggestion too that I made that terms of use should appear whenever students access the films, that you might want to just monitor levels of access and so forth. So these are all steps to bolster the fairness analysis. Fairness is dynamic. You can make your use more or less fair. So we were talking with online teaching with film about how to bolster these fairness arguments. Now, there was one point at which things came to a grinding halt, though, and I can remember a meeting in which we were all too quickly slapping ourselves on the back and popping champagne because everybody was really confident and happy with the fair dealing analysis. And then the question was raised, yes, but what if you need to break technological measures to copy or reformat the film? And this is when things did come to a bit of a screeching halt, because I had really no answer to this other than risk management. In the UK, there is an enforcement regime in relation to circumvention of technological measures. It's not subject automatically to exceptions like Section 32. To the extent there is a mechanism to get directions to allow you to circumvent a technological measure, it's really not fit for purpose. So as I said, this really came down to risk management. What did HEIs do? My sense is that, to be really honest, the library just turned a blind eye. That staff, that lecturers under 35 or 40 years of age all know how to break technological protection measures, and even some savvy 40 plus people as well. And so my sense was that you didn't send the digitization project or the reformatting project to an external third party. It was done internally, but that's just my sense, is that ultimately it was risk management. That was the only thing that one had available as an argument in relation to that aspect. And as I mentioned, there was an update in 2022, which really asked whether or not this fair dealing analysis was so closely tied to the conditions of the pandemic that there could be no continuation of these practices. And when I went through them, the pandemic certainly bolstered the argument that online teaching with film was essential, it was necessary, there were no reasonable alternatives. But having gone through them, many of the other fairness factors are exactly the same. And so my sense was that there wasn't some great change in the legal position. That said, as noted on the slide, we should take care with set and forget policy making in relation to fair dealing. That is, you don't just come up with a policy and then not think about it ever again, that you do need to regularly come back to see whether or not that policy needs to be updated, to see what practices are like under that policy. I mentioned this to Sarah and Elliot. I included on the slide deck some slides in relation to whether the next frontier could be CDL, and I'm happy to talk with them if there's interest in controlled digital lending amongst the people in the room. But I wonder whether I might just pause there, because I think I probably have sort of used up a fair amount of the time of this session, just to see if there's any questions from either of the hosts or anyone in the room. And I think while people are just sort of gathering their thoughts, I might just say a couple of sort of final things to tie together what I've just been talking about, in terms of the sort of tips for making the most of fair dealing, and trying to draw back from those quite detailed UK-based arguments to some more general points. But one is the importance of framing. And I think the pandemic really brought this into focus in relation to teaching with film. That if you rock up to your lawyer or your in-house counsel or whatever and say, we'd like to do X, will copyright be a problem? The answer will most certainly be yes, it's a problem, and quite likely no, that's why you should not do it. And I think that another way of framing that question is, we have got a mission critical activity that we need to do. How do we support access in a way that minimizes or reduces our exposure to risk? So it's reframing, and I think that the pandemic kind of did that inherently. We have these mission critical activities, there's no reasonable alternative, so what do we do? And I think too, with framing, the other framing device, which I think was really important in the case of online teaching and may be important in the case of controlled digital lending, is that we're just extending existing understandings and applications. The use of exceptions for teaching, for lending, is not unique or exceptional. It already happens in relation to analog versions or in-person versions of those activities. And also that exceptions are included in copyright statutes to facilitate important public interest goals, including education, including research. Secondly, and this relates to that first point, what is the best case you can make that fair dealing applies? So you may not have an instance where, in fact, in many instances where you're talking about fair dealing, you won't have a clear-cut answer, oh yes, it definitely applies. What's the best case that you can make? And so what I've tried to do today with the analysis in relation to film teaching and I'm doing in relation to controlled digital lending is what's the best case? And let's just see what the best case looks like, bearing in mind that considerations such as fairness are dynamic. So you can think about ways to improve your own fair dealing analysis through steps to make your use more fair. And finally, this idea about working with other institutions. So that was a really important part of this process. That said, and this actually relates to a question Katia has asked in the chat, which was that King's did not make its policy publicly available. Was this the stance that most HEIs took? And my sense, Katia, is yes, that was, that institutions weren't putting out there their internal policy, but people within institutions were talking with one another. So that's why you could get this confidence that you didn't need to see what King's precisely put in its policy to get an understanding about Kings's amenability to this approach to online teaching with film. And Katia, that's also why I sort of wrote the guidance, because I thought I can, at a personal level, make available my thinking about fair dealing as a more sort of detached legal analysis. So the guidance is from me. It's not an approved King's document, but Katia, it does contain a lot of detail. Yes, it is. And so actually, if I just go back here, if you go to the Social Science Research Network, you can get for free, that is for no money, you don't need to worry about the exchange rate, copies of both the original guidance and the updated guidance. And it goes through in detail all the legal arguments I spoke about today. And I'm very happy for the ADA to make the slide deck for today available separately as well. But it is quite detailed. So it is somewhat, it is somewhat oriented towards people who are going to get into some of the weeds of the copyright analysis, but I thought that was quite helpful, though, to include that level of detail, as well as some sort of summaries as well, or when I see things are appearing in the chat. So sorry about that. I've now sort of talked through some of the question time. I might just stop for a moment because I was just picking up Katia's point. But Sarah, Elliot, who's coming back to help out now?
That will be me. I'll come back.
Hello.
Thank you for that. That was great. There's another question that's kind of related that has come from Elliot. Just find it. You mentioned peer support between the copyright officers at universities in the UK.
Yeah.
How important is this kind of exchange for advancing copyright in practice?
Yeah, so I thought, I think this was one of the things that was crucial. And I've certainly, my observation is that in Australia, it's improved and improved as well over the years. That, it will come as a great surprise to you, Sarah, that I have been, my first project with cultural institutions was 20 years ago. Can you believe it? I was only a teenager and already at the University of Melbourne as a research fellow. And my sense at that time was that the cultural institution sector did not yet really, in Australia, did not really have it sort of act together yet in terms of speaking with one another, collaborating in a meaningful way and a coordinated way. So when you had in 2006, there was or 2005, there was a review. Who knew? It's been happening for forever. A review about copyright exceptions, right? The cultural institution position was all over the place. Everybody wanted more specific exceptions, more fair dealing, more fair use, just more. And it wasn't a kind of coherent position. And I think that during that period in the noughties, my sense is that institutions really started coordinating more, but to the extent there were already some bodies that were sort of like the Copyright and Cultural Institutions group, the work that I'm not too sure how long has the ADA, when was the ADA established?
Over 20 years now.
Yeah, so ADA starting to perhaps sort of really get more involved, that it really sort of changed the level of coordination. And I think one of the things is that people need confidence. They need to test their ideas amongst one another. And I think that, so what worked in the UK was not just having these groups, but also having I think the closed webinars were very important in talking about teaching and film, because people needed to ask some difficult questions in an environment of people who were going to be able to help answer them and sort of almost figure out what we're all comfortable with. Bearing in mind that we're not insuring one another, it's not actually an official collaboration, but it certainly helped a great deal. So it's something which I really would suggest that the closed webinar is a great way, or those sorts of closed sessions to build practice.
Thank you. I've got another question here from Richard White, and he says, Kia ora, Emily, I'm interested in the word illustration. Was this borrowed from some other part of the Act or case law or somewhere else? It could be taken quite narrowly, but your film screening example is quite a broad interpretation.
Yep, that is correct. That's why you shouldn't use it. So yes, illustration did come from other international instruments. So and so the UK, rather than just saying let's call it for what it is, education, the drafts people were very much thinking about the language that appears in the Berne Convention and also in the Information Society Directive. So that's how they came upon that language. Canada just says fair dealing for the purpose of education. And in fact, not only that, when you look at the Canadian provision, like, you do not need to get out the colored pen set to color in the limbs. It does not have this amount of inbuilt statutory qualifications. So yes, that's where illustration comes from. And I do agree that my approach pushes that language. And that there was, as I mentioned, guidance from the Intellectual Property Office initially, which said it's about illustrating a point. And certainly, you don't tend to watch a film to illustrate a point, and for controlled digital lending as well. So you can say that you don't need to read an entire book to illustrate a point. So it was really pushing back against that. But I think there are, as I said, other statutory indications that that's the right approach to take, including what the DSM directive now says as well, which I've also extracted on the slide. So that's how I got there. But this is one of those instances where it's like, it's being really honest about the strength of the case, right? That point could be put against this interpretation, that illustration for instruction is not education, it's just much narrower.
Cool, thank you for that. And just going back to you when you were talking about, I'll just try and find the question, sorry. TPMs.
Yep. Yes.
Where's it gone? Sorry.
That's all right.
So this is also from Elliot as well. So Professor Rebecca Giblin and Corey Doctorow in the new book have raised compelling points about how TPMs play out in reality, actually working against artists and creators and propping up online business models. Is this an area that we should be advocating to reform?
I think that yes is the short answer, but you have to prioritize, right? Because you don't have to prioritize, but you risk rocking up to the government with your list of demands and not getting any of them, or getting the ones you want the least. So in terms of, yes, there needs to be some thinking about this. And I would actually put it fairly high up the list of things to deal with, because it actually turned out to be the one area where I had no good answer. It's only risk management. That's all you've got, is that you're assuming that because if your Section 32 case is sufficiently strong, the only thing you're left with is breaking the technological measure, and that's unlikely to be litigated. A judge would not look upon it kindly, and so forth. But it really is just a risk management argument. So I do think that, at least as a starting point, one needs to ask about, for instance, TPM enforcement regimes being subject to the same exceptions as the economic rights of copyright. So whether or not, instead of having to do these applications to the minister or the secretary or the comptroller, that in actual fact they're just there. But I think too, with the work that of Giblin and Dr. O, I think they're also talking to about some much bigger, important questions about how TPMs are used to sort of create and control markets. Certainly that's a sort of then the sort of bigger competition concerns about how users get locked in to various platforms, and TPMs playing a large part in that.
Yeah, absolutely. Well, thank you for that. I'm just wondering if you've still got a few more minutes, if you would like to continue. Does anyone have any other questions? You feel free to continue with the controlled digital lending. Richard is just...
I might do that. And I was just looking at at least the chat. I haven't got the Q&As open to see if there's anything there, but Richard saying, so useful, by the way, that the UK Act specifically says you can't contract out of statutory exceptions. Yes, that was also introduced as part of the 2014 reforms, is the no contracting out being added to quite a lot of the provisions. Why don't I just give you the very quick whistle-stop tour about then CDL? Could this be the next frontier? Controlled digital lending became of interest during the pandemic, well, of particular interest during the pandemic, because people couldn't actually turn up to libraries. There's been, CDL has largely been practiced in the United States by reference primarily to arguments under fair use. But there has been interest in the UK about whether UK institutions, UK libraries might also roll out controlled digital lending. And so one of the projects I'm currently working on is whether or not that might also be undertaken by reference to fair dealing, and also perhaps by reference to other exceptions. I'm not too sure how much there's been a discussion about CDL so far in Australia, but the key elements of CDL are set out on this slide. That what libraries are doing with CDL is they take a lawfully acquired hard copy title, they digitize it, and then they lend digital as well as physical versions. However, on the basis that there is a strict owned to loaned ratio. So if you have 3 copies of the title, only 3 copies may be loaned at any given time, whether that's 3 physical, 3 digital, or some combination of digital and physical. So that to the extent the physical title is on the shelf, when the electronic version is loaned, the physical copy is withdrawn. And all the terms of the digital loan mirror that for physical loans. And that there are technological interventions to limit copying and redistribution. And what where I'm working on currently is fair dealing and other exceptions arguments and whether they might permit CDL. And at the moment, the sort of position I've got to is that I think that there is a good argument that academic libraries could do some controlled digital lending under Section 32. And I think that the rubber really hits the road on fairness. And I think the fairness analysis for CDL is not quite as straightforward as it is for online teaching with film. As indicated on the slide, 2 particular reasons for that, and that's the copying of entire works and the concern that CDL might impact adversely on ebook sales and sales of subscription packages to other databases and platforms. And so I think that to the extent that in UK institutions are interested in CDL, they have to think about, well, how do we respond to those arguments? On these slides, I've got a couple of the sort of prominent ones that one might point to with CDL, including the lack of an ulterior purpose. So if institutions, if academic libraries are doing CDL, their only purpose is to facilitate education. They don't have some other purpose. The digital scan is available only to members of that educational establishment. It's not going out to the public at large. And that the own to loan ratio is crucial, right? Because you're not borrowing beyond what you could do with the physical book, and you've then got measures in place to stop those digital copies being used in other ways, so retained, loaned around, etc. And my sense too is that to the extent that there are concerns about CDL in terms of market harm, that this relates not just to for the loss of, not so much to sort of loss of income, but to competition. So it goes back to that point with that question about Giblin and Doctorow's work about actually we've got copyright and competition law really coming together here. So what's the problem for publishers? Well, I think the problem they will say is people aren't then buying ebooks, right? So I think that there are in terms of market harm, that this is why I think this is why CDL has the potential to be much more controversial. That said, I think there's a number of responses. First of all, that the publishers also have to be careful that they don't set themselves up in ways that are anti-competitive. If we didn't have a minute to go, I'd have the pleasure of sort of talking a bit more about how copyright and competition law interact in that regard. But also that, there's other arguments too about fair dealing being used to protect outdated or indeed undesirable business models. And I think that where we sort of end up, because I realize we need to pull this together, is it may well be that for CDL, you start with the titles that are orphaned, are out of print, which there's no digital version, because that removes that argument about, oh, but you didn't buy our ebook, you didn't access the digital version. So that might be, if you're wanting to dip your toe in the water in relation to CDL, that's where I would start. But again, it goes back to this idea of fairness being enhanced by these measures, in this case, of this own to loan ratio. And indeed, and this is a final point I'll make, there is in the UK statute an exception that copyright in a work is not infringed by the lending of copies of the work by an educational establishment. So it's similar to the Section 34 bolster for online teaching in films. The UK government wants educational establishments to do lending without infringing copyright. And so that bolsters the Section 32 argument. And indeed, I'm also considering whether it could be a separate limb under which CDL could be undertaken. So Sarah, that's kind of the very speedy overview of CDL.
Well, thank you so much for that. It's very interesting. Does anyone have any questions? I'm aware that we're over time now. Emily, if you're
probably all hungry and want dinner,
just stay around for a couple of minutes. There may be questions. But other than that, thank you all for coming. And these videos will be available on our YouTube channel in a few weeks. So,
and we have a question. Do you know what people may leave? But I'm going to answer Richard's question because
sure, no, feel free to keep
people
talking.
can go. They can watch this bit later if they want to. And the question was, would CDL mean publishers just stop publishing in print so that library can never own new books but only license them? Interesting thought experiment, Richard. I actually hadn't thought about that. But one of the things which US practitioners do say about CDL is it's not an ebook answer, and indeed that it is a backwards in time strategy for the items in the library collection for which there is no digital version available. So I think in the US, it tends not to be for recent titles where there's an ebook or a digital version that's available. So actually, the bigger threat for CDL, if you take seriously the reasonable alternative argument, is publishers just finding some PDF of every book they ever published and making that available, right? So in terms of the market harm, that could be an issue with publishers going back to make more and more stuff available in digital form. But I think that, as I mentioned, there is a suite of things in the collection where even if they're orphaned, if they're out of print, it may be that no publisher is ever going to take those steps. So those items might remain as quite the best case for CDL. And then I think as you're moving into titles where publishers do have a digital version available, that's when I think you're going to have to start thinking a bit more about some of those other aspects of the fairness analysis. I wouldn't suggest that fair dealing wouldn't still apply for those titles, but I do recognize there'll be more controversial. So I wouldn't start there. Like, I think in the UK, it's encouraging people, if you're going to do CDL, to start with the easier stuff, which will be out of commerce works, in essence.
Thank you for that. I do have a question. I think there's people are leaving, but my question is,
right.
How does the public
they enjoy dinner, everyone who's leaving.
How does the public lending right? So the Australian government has just introduced, I guess, in the national cultural policy, the public lending right for ebooks. How does that work with controlled digital lending?
You basically need to, well, in terms of educational establishments, they are outside of the public lending right in the UK. So, so that provision in section 36A makes it clear that lending by educational establishments is outside of the public lending rights scheme. And that is permitted by the Rental and Lending Directive in the EU, to the extent that Britain was once European. So one of the things, and I'll be honest, I haven't sort of, one would need to think about a bit more, is what happens once you're moving into libraries and volumes that are within the public lending rights scheme. And so I think that is something I haven't really addressed yet, but you raise an important point to make sure it's covered. It may well, because I think that but just to sort of complete the circle, the UK statute was updated a while back for the lending rights scheme to apply to electronic books as well, to ebooks as well. So it has been updated. It would then just be a question about how do you make sure, if you've got CDL, as you say, how does it map onto the lending rights? So that is something which, for academic institutions, it's an issue that they avoid because they're not in it to begin with. But it's a really good question.
Yeah.
Watch this space, as they say.
Yes. Okay, cool. Well, I think we might wrap it up there, unless there's any more questions coming through the chat. But thank you so much, Emily. That was really interesting. And
thank you for everyone who's hung around. There's still a good number. It's been lovely to connect with you all virtually.
Yes.
I hope, Sarah, that we can do an in-person event so I can see people three-dimensionally. Happily enough, I'm sure that all of us look exactly the same as the last time we set eyes on one another.